I'd like to call this meeting to order in acknowledge that we are in Treaty 1 and Dakota Nations territory and the traditional homeland of the Métis Nation. My name is Harvey Diamond. With me is Lynn Nisbet to my left. And farther to my left is Brett McIntyre. Our secretary is Balhan Rojo, and the city assessment department is represented by Marina Tenawara and Michael Portrait today. Please note that we are placed in a waiting room until.
Oh, sorry.
Oh,
you
so
can go to number 4.
We'll be hearing applications for revision of the assessment in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application. We will limit discussion to those matters. The statements that are made at the hearing are sworn testimony, and anyone speaking to a matter must be sworn in. Be advised the comparison of assessments of properties are not considered as evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions the basis of the evidence provided at the hearing and issues a written order that we mail to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed the Manitoba Municipal Board if matter pertains to assessed value or classification, or to the Court of Queen's Bench if the matter pertains to an application for exemption from taxation. And should you wish to appeal, information on how to do so will be included with our order. With respect to the hearing process, I will confirm the points of appeal with each party and on each property prior to each party being addressed and the applicant following swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will be given an opportunity to summarize if they wish to do so. Once all the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each matter on the docket today. The session will close after all applications have been heard, and the board will deliberate in private and make its decisions. We receive the board's decision by written mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. And our first matter will be 939 Coronine Avenue, and we can swear in the parties.
Madam Assessor, please state your full name.
Marina Tenawara.
And you affirm the event about to present is the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Thank you. Mr. Applicant, please state your full name. You are muted.
Rocky Neufeld.
Thank you. And you affirm the event about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I don't know if Mr. Mercury went over this, but he's only here for 350 North Town, and I think he has some other matters to attend to today. So, is it possible we can start with that?
Okay.
Yeah.
So we'll start with item 3 today. I will have to admit Mr. Barber.
Correct.
We need the other assessor.
Right. Yeah.
Mr. Assessor, could you unmute yourself, please? Okay. Please state your full name.
Michael Courtfront.
And you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Okay, Mr. Applicant, please state your full name. Sorry, Mr. Mercury, that's
Oh. James Mercury.
And do you affirm the evidence you're about to present is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So we're dealing with 350 North Pound Road, and there's some preliminary issues that have come up. So we can hear what those first, obviously. The preliminary.
Thank you, Mr. Chairman. Yes, we have some preliminary matters that we'd like to have addressed, specifically relating to the applications received for the 2019 and 2020 supplemental assessments at this particular location. The issue essentially is that it's the assessor's position that the applications were received long after the 20-day application period, long after it had lapsed. If you look, I've submitted some material to this effect, summarizing our position, and I'll go through that material for you. So starting on page 2, again, as I summarized, the issue is basically that we feel these applications were received well after the 20-day application period. The legislation on in my package on page 2, paragraph 2, relating to supplemental notices is found in section 342 of the City of Winnipeg Charter. The charter states, in essence, that the tax collector must send to the person in whose name the property or premises is assessed by mail supplementary tax notice that includes a reference to the right to apply for revision, as provided for in section 329. At section 329 of the charter, in paragraph 3 of my submission, it states, particularly in item B, assessment rolls are subject to revision under Part 8 of the Municipal Assessment Act. If under section 341 supplemental taxes are imposed and a supplemental tax notice is sent under section 342, an application for revision in accordance with Part 8 of the Municipal Assessment Act may be made within 20 days after the day the amended or supplemental tax notice based on the amended assessment was received by the person to whom it was sent. And in paragraph 4 on page 3 of my submission, when it comes to notices sent by mail, the charter does speak to when that stuff is, when mail is considered to be sent. At section 117, subsection 2 of the charter, it states a copy of a notice, order, or document to be sent by mail, item B again, is deemed to be received by the person on the third day after the day it is mailed. So as it relates to the subject parcel and these supplemental assessments specifically, on the middle of page 3, starting at paragraph 5, the City of Winnipeg Assessment and Taxation Department sent out supplemental assessment notices for the 2019 and 2020 tax years on November 24th, 2020 for this specific roll number. Copies of which are found now. I appreciate you might be looking at this electronically, tab 1, or in this case, page 7 of my submission. Are 7 and 8 are copies of the notices that were sent to the owners. The notices were sent to the registered owner of the property, IG Investment Management Limited, at the address of 1 Canada Centre, 447 Portage. And that is the address for service that we received in the title transfers and is what is registered at Winnipeg Land Titles as the address for service at this property. I will draw your attention or make note that the postal code that we've used on the notices, it does vary from the postal code in the application filed by the owners. But we have verified that the application shown on our notices is exactly as the service, the address for service. It is also exactly the postal code used and that shows up in the CEDAR website, which is the System for Electronic Document Analysis and Retrieval used by Canadian Securities Administrators for IG Investment Management, so they do show the same postal code. And Investors Group themselves, on their website as of this morning, when referencing people to contact their corporate contact center, does use that same postal code that we have on the notices. So we're satisfied, even though there seems to be a discrepancy there, that we were sending it to the correct place. And we had been sending notices, both assessment notices, tax notices, and income and expense mailers to that address dating back, as far as I could see, as May of 2016. And we have no record. I checked again yesterday. Our tax department had no record of any returned mail, notices, bills, or otherwise coming from that particular customer. These paragraph 6, those supplemental notices were sent by ordinary mail as outlined in the charter. And again, we have no record of anything being returned as undeliverable. And if we consider section 117 of the charter, we would have deemed those notices to have been delivered on or around November 27th of 2020. Paragraph 7 on the bottom of page 3, in accordance with 342 of the charter, the notice does inform the addressee of the application for revision having to be made within 20 days of receipt. And if we include the 3-day delivery period outlined in 117, the deadline to a filed application on those two notices would have been December 17th of 2020. The current applications before the board found a tab 2 in my submission, or if you're looking at this electronically, page 10, were date stamped as received by the board on June 30th of 2021, a full 195 days after we've estimated the application period to have ended for those two particular notices. On page 4 of my submission, paragraph 9, the city was notified April 20th, 2021 through our 311 call center of a request for a mailing address change on the subject property and the adjacent parcel. And this was a change to the current property management group, which is Colliers International. That email request is included on tab 3 of my submission, starting at page 16. That was the first indication we had that there would have been an address change for this location in terms of where the items should be delivered. And that came 124 days after the application deadline for these supplemental notices. The Assessment and Taxation Department has no record of reissuing the supplemental notices for 2019-2020 to this new address. There is an affidavit attached with the applications received by the board, which I've included on page 12 of my submission, following the applications to the board. The individual who signed this affidavit is not the one to whom the notices were addressed. And the individual was not, we had no instructions to send material to that individual until after April of 2020, or until April 20th, 2021. So considering that neither of the parties are considered the persons to whom the notices were sent, referred to in section 329 of the charter, it's our submission that these applications were received well after the deadline to have filed, and that sending these notices to a third party or delivering them to a third party does not restart the 20-day application period contemplated in the charter. So it's our position that these applications for 2019 and 2020 specifically were filed late and are invalid. At paragraph 13 on page 4, it's also our position that this panel does have the authority to dismiss these applications with reason. And that's why we bring it before you today. So in summary, on page 5, it's our position that the 2019 and 2020 supplemental notices were sent to the registered owner in accordance with the charter. The notices included a reference to the right to file application within a 20-day period after receipt. They were sent to the registered owner and to an address that we had on file dating back to 2016. In the absence of no returned mail and allowing for the prescribed 3-day delivery period, we would have had an application deadline date on or around December 17th of 2020. And since the applications on these notices were received by the board in June of 2021, long after that application period had ended, it's our position, and considering that the individual who signed the affidavit is not the one to whom the notices were originally sent, we maintain that that these applications were sent in late and are considered invalid and should be dismissed.
Here. Mr. Mercury, any questions?
Yes, I do. Thank you, Mr. Chairman. Mr. Courtfield, you made several references to the legislation, and specifically Section 329 of the City Winnipeg Charter. Is there anywhere in the City Charter or in the Municipal Assessment Act that directs specifically where you are to send a notice, an assessment notice or a tax bill, whether that be to the address of the subject property, the address noted in land titles, or some other address? Is there any specific reference in the legislation?
Section 342 of the Charter says, as you'll see in paragraph 2 on page 2 of my submission, the tax collector must send to the person in whose name the property or premise is assessed.
The question was related to the address specifically, not the identity of the person, but does it say which address to use?
It does not in that particular legislation.
Okay. And I understand your practice is generally to send it to the address for service on title, correct?
Correct. Until instructed otherwise.
That's right. So it is not uncommon, you would agree, for commercial property managers, for example, to advise you that the proper address for service should be directed to them, because typically they handle and administer the payment of taxes and all other tasks associated with the assessment process, correct?
It does happen, yes.
Yes,
and
fairly regularly.
Yep.
Okay, and so the affidavit that you mentioned, Mr. Courtfield, was an affidavit of Linda Minuk, and attached to that affidavit was a document titled Notice and Direction. You see that?
Yes, I do. Page 13
Okay.
of my submission, yeah.
Yes, and you'll note, you state that the first notice you received of a change in address was at sometime in 2021. However, you'll note at paragraph 1 of that notice, it states that effective as of January 1st, 2020, the new property manager at the property will be Colliers International, and from and after the effective date, you are authorized to provide invoicing, contract, and account acquires to Colliers, Linda Mikulik. Sorry, I said Minuk. And the City of Winnipeg is one of the parties that are the recipients of noted in this document. Correct?
We did not receive this document until April of 2016, when we asked for authorization from Colliers related to their request for address change.
So you say April of 2016.
Or sorry, April of 2021.
Okay, you say you didn't see this document. I did see reference to an email in 2021, correct? But does it not strike you as somewhat odd that this is dated January 1st, 2020, but you wouldn't have received it until a year and a half later, approximately?
I don't work for IG Investment, and I can't speculate as to what process they put in place to deliver this particular what appears to be a form letter giving blanket authorization. You'll note that it's addressed to all vendors and sort of lists off a who's who. The first we saw this was when the request for address came in April of 2021. We asked for authorization for the change of address, and this was what came to us at that time.
How can you say that for certain, personally, Mr. Courtfield, that is for certain this is the first time you received it? What steps would you have taken?
We have a very stringent process in our tax department and our data services department that vets all of this stuff.
Okay.
It's likewise for tracking returned mail. We appreciate that this is time-sensitive material and that there are potential financial penalties when tax bills don't get delivered to the right place. So they are very rigorous in their process.
Well, I'll let Mr. Neufeld speak to that and when he gives evidence in terms of how rigorous the city is in terms of tracking these documents. But the next question is, did you have a chance to look at the actual tax statement, history of tax payments for this property, Mr. Courtfield?
I'm not sure what you're asking.
Well, would you be aware that in fact that there were several missed payments, and that this property was in tax arrears for not paying the taxes on a timely basis? Were you aware of that?
I am not aware of that status.
Okay, and if you become aware of that, would that not be a signal to you that perhaps documents aren't being sent where they should be?
We don't get return mail. Our obligation is to send it to the registered owner until instructed otherwise. And
but if you're not receiving your taxes payments, would that not serve as somewhat of a red flag, particularly a property of this nature?
Our communication would continue to be with the registered owner until they send us specific instructions to the contrary.
Those are my questions. Thank you, Mr. Courtfield.
Thank you. Any questions of panel members? Ms. Smith, do you have any questions?
I don't just yet.
So McIntyre?
I just have one comment on the assessor's submission on page 13. And this is more for Mr. Mercury. Why would the IG Wealth Management not identify the addresses and departments and vendors in a notice such as this, so that where it was mailed to? For example, if they only sent it to the City of Winnipeg Planning Department, I'm not sure the assessment department would know about it.
Well, if that's a question for me, it may be a question better for Mr. Neufeld, but what I can note is that this is very specific address relating to 350 400 Northtown, which is a sister property. So it's not, this is a very specific location in terms of the number of notices that would need to be sent by the city to this particular property would be fairly limited. But I can certainly defer to Mr. Neufeld, who may have additional information on this on behalf of Colliers. But perhaps, if I may, if I may request of the board, perhaps we could just proceed with our submission and evidence, and then open it up to full questions, because you may have maybe a more complete picture once you hear everything from Collier's perspective.
I think that we should deal with the delivery matter and then decide if we're going to hear evidence.
Yeah, this is in relation to the submission in the preliminary matter, because it relates to the notice and how it was given and the background to this. So Mr. Courtfield has given evidence. I'd like to give Mr. Neufeld an opportunity as well to speak to some factual matters. That's all.
And certainly in your response to the city's application to, you certainly have, Mr. Neufeld, give any evidence you think is necessary for that. But
right.
I don't want to proceed with the matter itself and the evidence on it until we know if we're going to even hear it.
The evidence I'm speaking of is in relation to the preliminary matter as to whether you can hear the 2019 and 2020 appeals, not on the merits of the actual valuation issue.
That's fine. I have no questions, so you can proceed.
Okay, thank you. Mr. Neufeld,
Before you continue.
sorry, yes.
So my question is still on the record as unanswered.
Well,
Until we hear from Mr. Neufeld.
okay. Well, I provided based my information. I'm not the witness here, but Mr. Neufeld, perhaps can you provide some background from your knowledge as a representative of Colliers and your information here, just with respect to the manner in which this document would have been sent, and let me just start with that in terms of your understanding. You're on mute there, Rocky.
I was just getting it in front of me. My understanding is that on or around December 6, 2019, the letter on the assessor's page 13 was mailed to the city of Winnipeg in regard to 350 and 400 North Town, and by regular mail. And subsequent to that, we did receive, I know Colliers manages both properties, and we did receive the 400 North Town information, but we never received the 350 North Town. We've also been appointed as their official agent. There's a recent letter on the page 14, but we have a power of attorney on this in our files. So we have the power of attorney to deal with this matter. I didn't provide a copy of it, but that's part of our management agreement. And Linda Mickluck is the one who's empowered with power of attorney on these matters. And she made her own efforts in April of 2021 when she didn't have any communications, and that's what the assessor provided in tab 3. And in tab 3, there's a series, a bunch of email correspondence with the city. On the third page of that, answer to one of the other questions, the roll numbers were listed as to which properties we were looking for, and you can see the top one is the subject property. So this was our follow-up to the December letter, this April 2020, the December 19 letter, our April 2021, that we were still looking for it. There's never been a hitch with 400 North Town. Here's the addresses were in order. I know because I've received the notices myself every year. Both are owned by the identical party, IG Investment Management Limited. So that was the answer to that question.
So just to clarify, prior to 2021, and subsequent to the date of this document, January of 2020, with respect to 400 North Town, Colliers was in fact receiving the assessment documentation?
That's correct.
Okay. And I asked Mr. Courtfient as to whether he had looked at the tax statement or history on 350 North Town and whether he was aware that there was in fact arrears penalties. Can you speak to that, Mr. Neufeld?
Yes, we finally got a copy of the tax bill, and we did it by actually looking it up on the pay site, and it was on or about June 21st of 21, and we looked it up and just we discovered what the tax bill was and what the arrears were. Sorry, I had a bunch of documents here. Okay, at that point, we found the tax bill for, and this was on the city site, the 2021 tax bill, which had arrears of $652,000, total payable $1,058,000, and included in that were about $62,000 in penalties for not paying taxes from the time, I think that the roll went on the record by the looks of it to 2000. Sorry, I'll get the right number here in a second. Oh, okay. I found it. No, I didn't. Okay, so I found the date we found it was June 22nd of 2021, and from the city's pay site, and the penalties. The site came on stream in 2013, and payments appear to have been made in 13, 14, 15, 16, 17. And then that was the end of it. No payments listed. Oh, I'm sorry, 18, there was a payment. And that was the last 19. Okay. Until the last payment on the account, it was put on tips. January 2019, it was put on tips. And at that point, the account balance was zero. The tip payments came in at regular amounts. And then the assessments, the supplementals came out in November of 2020. And at that point, I imagine the tips stopped because the increased taxes were $300,000 or $500,000 a year, and then the penalties began, and the penalties were about $60,000. Oh, sorry, 16, 15, 15, 15. 14. So that's all about $90,000 in penalties on the account.
So just to clarify, can you just speak to what led to the April of 2021 email to 311?
That was an administrative matter because we hadn't received any, our property managers hadn't received the latest tax bills, and we were dealing with a period ending of reconciliation. And the property manager, Linda Micklick, then contacted the city, knowing that investors had notified them of the address change and looking for it. And she was rerouted through 311 and told to do the procedures that were indicated on the emails you've already read. And she proceeded to do that. And after 2 months, there was no response received. And then she engaged us to track it down, and we found the tax bills with the penalties from the city's pay site. And then we started this process going, filing our appeal and our affidavits on July 5th, which was about 14 days after we found the problem.
Okay. I just want to ask you one final question, and this relates to the City of Winnipeg's tracking system. Mr. Courtfield has expressed a high degree of confidence that they are quite meticulous in tracking changes of notice of address for these types of documents. And I know you have been involved in a number of these cases, particularly with respect to deferral order requests and so forth, where this issue arises. What is your experience from the agent, from the property manager and agent's perspective in terms of whether notices are meticulously tracked and cataloged?
No, I think they're not tracked. I think that they have the ability to go back in time and look at the record, but they don't do anything about it. It's sent out and not dealt with. The assessment and taxation department is one entity, but taxation and assessment aren't always on the same page. For years, I have been receiving the personal tax. I personally have been receiving the tax bill for $850 Keewatin. And we keep telling the city, why are you sending this to me? This isn't mine. But this just goes on. It does happen from time to time, and they go through their administrative process. They forget all about it. They if there's an arrears, nothing's done about it until it hits tax sale time. And this, we narrowly missed the tax sale time. We were in tax arrears, but we only caught this because we have an annual reconciliation time where we look for these things, and this is when we caught it. Had we not caught it, I imagine there would have been a registered letter at some point for tax sale sent. Investors on Portage, it's true that they do represent the syndicate that owns the building, but they don't manage any of their own properties. Every single one of them is done by a third-party property manager who has power of attorney, and we are the ones in Winnipeg. But going back to your original question, they have a series of mechanisms that trigger their actions. One, generally it's if there's been a replot, or there's been a permit that's been closed off. And so the city gets these permits or gets notice of these permits from property and planning, and then they do their assessment, and that's about it. They will, as I agree with Mr. Courtvient, that they do default to the title, but they miss an awful lot of the notices. This isn't the first time it's happened with us. Generally there's about 2 or 3 of these every tax cycle where they've missed them.
Okay, so with that, I just wanted to make a few comments in summation on this issue for the panel members and the board. Just with respect to the evidence, you have Mr. Neufeld Collier's evidence that there was in fact this notice sent effective January 1, 2020, well before the supplementals were issued. It was in relation to both 350 and 400 Northtown. There hasn't been any issue with notices being sent to 400 Northtown. For some reason, there was not a change to send these documents to Colliers for 350 Northtown. Obviously, we're not in a position to explain that, other than there's plenty of evidence that these things do in fact happen from time to time. The best evidence that they weren't receiving notices is the fact they were in arrears, which is a bit odd for this particular property with history of making payments consistently. So for whatever reason, they weren't receiving these notices. It's the property manager who administers these types of matters. So as we know, that's why these things do happen, and I would suggest that's why in the City of Winnipeg Charter it speaks to the date of receipt by the person. It's not in the Board of Revision manual as well, which is included in our evidence. It is quite clear that the board has a policy of accepting evidence relating to receipt and the time of receipt. So this is not new. And at the end of the day, the board has an obligation to ensure a fair process. I have included a couple of decisions for the Board of Revision to consider in our material. I will pause to say that most of the time these issues arise with respect to notice and who received the notice or whether they received the notice on a timely basis is, as the board is aware, most commonly in deferral penalty cases. We don't typically have this issue argued on whether the appeal was filed on a timely basis, but whether information requests were received or responded to. And in those cases, we we commonly engage in a discussion as to whether the city assessment department has in fact sent it to the correct address, whether there's evidence that they did, and whether the owner received it and responded to it. And so most of the cases we've seen are in relation to that issue. I have given you a municipal board decision relating to involving Manitoba Hydro and their head office building on Portage Avenue. Hopefully the board has that. I believe it was filed as a separate document, if I'm not mistaken. Hopefully everyone has that document. It's a municipal board decision dated August 27, 2019. Does the board have that decision? I just want to make sure everybody has that document. You do have it? Okay, thank you. So the issue, there were a few issues here that we don't need to go into all of them, but one of the issues as to whether the notice, the request for information in this particular case was sent to the correct address. And I just want to note at page 14 of the decision, there is, and we've highlighted the evidence of the assessor in that case, which is consistent. Mr. Courtfiend's evidence is that if a request to change the address is received from an owner, the city's data services would receive and request them, and the department would make the change internally for all assessment-related notices, tax mailings, INE requests, etc., to the changed address. And what happened here is they sent it. Manitoba Hydro in this particular case actually did send such a request, but the evidence was that for whatever reason, the city didn't process that request and continued to send it to the original address. And they really didn't have an explanation for it other than it may have been a resources issue. And on the basis of that, the municipal board, amongst other reasons, declined to issue the deferral penalty. So if you go to page 24 of that decision, fifth paragraph down and highlighted, the evidence reveals that after the department sent the first INE request, the department received a phone request to change the address. And Mr. Pohl confirms that once a request to change an address is received by an owner, it's practice of the department to then change internally all taxation and assessment related notices to the new address. And that the evidence reveals that the department did not follow its own protocol regarding an owner's request to change of address. So we've seen this on many occasions. This is one of several examples we've seen where this is not a situation, as I would suggest respectfully, as Mr. Courtfiend has described, that there's meticulous compliance with these types of changes. Errors do happen. It's not a criticism of the city. These things do happen. But the result of that, these slips on occasion, is not to penalize the taxpayer, but to give them an opportunity to be heard and have their matter heard on its merits. And so in this particular case, I mean, I don't know what happened here. Clearly, the city processed a request for 400 Northtown. They didn't do it for 350 Northtown. I obviously don't have the explanation for that, but it occurred. The last decision I want to just bring to the board's attention, because it is somewhat analogous to the present situation, is in the supplemental, in the brief, the Collier's brief, if you have it. We have included a case from the Manitoba Court of Queen's Bench in IKEA versus the City of Winnipeg Board of Revision and the city assessor. That particular case, what happened there was IKEA was a party to a business assessment appeal. A notice for hearing was issued by the municipal board to the property owner, and for whatever reason did not come to the attention of the agent. Nobody could really track where that mail went or whose attention it came to. The matter came on for hearing. The board dismissed the case without a hearing, even though there was evidence that there was an agent involved. There was no attempt to track down the agent or counsel for the party. the taxpayer had requested an opportunity to have the matter heard on its merits because of, for whatever reason, didn't receive notice of the hearing. Both the city and the board refused to comply with that request. That resulted in a judicial review application hearing before the Manitoba Court of Queen's Bench. And to say that the Mr. Justice Abra had heard that matter, to say that he was unhappy with that state of affairs would be an understatement. He emphasized, the decision can be found at page 75 of the brief. This is the judicial review application, and in fact, what he ordered was that the board was mandated to hear the matter on its merits. This was procedurally unfair to deny the applicant an opportunity to be heard. And actually, you can see at the bottom of page 78 where he notes that there has to be a better way so this kind of situation doesn't arise. Not enough for the board to take the position that since many applicants show up, this sometimes somehow implies that all appellants must be receiving the letter notifying them of the hearing date. I would suggest the same thing applies here. The fact that certain taxes are paid because the city is sending it to a particular address doesn't mean that this particular appellant was ignoring those notices. And so, to summarize this case, the court clearly ruled in favor of the principle of fairness, gave the taxpayer an opportunity to be heard, ordered the board to hear the matter, and also, in the course of so doing, ordered $10,000 in costs against both the city and the Board of Revision as a result of its failure to allow the matter to proceed. And so what we're saying here is, the point here fundamentally is one of fairness, and errors and omissions do happen for whatever reason. 350 Northtown notices were not directed to Colliers. Not certain why that is the case, but that is what happened. One would think the city in these circumstances would not oppose the supplementals being heard on their merits, and in light of the evidence that has been filed. So that is a summary of my submission. Of course, if you have any questions, I'm happy to address them. Thank you.
Thank you. First of all, Mr. McIntyre had a question. Are you satisfied with the answer at this point? I just don't want to get an answer to that.
Not quite.
Okay,
Chairman.
so maybe we should get that first, and then we'll let Mr. Corford ask any questions he might have.
So the question, I believe, was as I recall, why was it not directed to a specific department? Is that was that the nature of the question?
Well, certainly because it was a general city of Winnipeg as well as a Manitoba Hydro and other years.
Yeah, I think what I could say to that only is to repeat or summarize Mr. Neufeld's evidence is that the city clearly received it, because the evidence of that is they changed the notices, the address for 400 Northtown, which was also on that document, but for whatever reason didn't change 350 Northtown. So they clearly received it, they clearly processed it, and they acted on it. Why they only changed it for 400 rather than 350 is a question for the city, I suppose. But that's, I think, the most we can offer you. I do acknowledge it does not specifically state the assessment and taxation department, but most of these requests go directly to 311, which is a general intake, at least within the last few years. Sometimes by email, sometimes by mail, sometimes by phone call. And I would agree, as a matter of best practices, I would certainly advise clients to be as specific as possible, but the notice is what it is, and the city did act on it.
Well, further to that, and this is probably a question for Mr. Neufeld, you are agent for the owners, correct? Oh, he's muted.
Yes, I am.
And you're agents for 350 and 400 Northtown?
Well, no, we'd never done work on 350. Our engagement was on 400, and I do specific work, not general work. So when the tax notices come, I would have been engaged for 350.
Okay, thank you. That's all my questions, Mr.
Thank
Chairman.
you. Mr. Corcoran, any questions?
Yes, I do. Thank you very much. Either Mr. Mercury or Mr. Neufeld, perhaps I was going a little fast, but we've heard comments from both of you that 400 Northtown was changed, and it must have been changed as a result of receiving the notice from Investors Group. But you'll note on page 4 of my submission, paragraph 9, that in the 311 inquiry, the request for change of address came for both 350 Northtown and 400 Northtown. If you go to page 17 of my submission, where the original email to 311 is copied, and I've checked, it appears to be exactly the same as the copy provided in Mr. Neufeld's evidence. You'll note that they are requesting a change on 2 roll numbers, both for 400 Northtown and for 350 Northtown. So if the city was sending notices on 400, can you explain why Linda McClick would have been asking for an address change on both?
Well, sorry, go ahead, Mr. Neufeld.
Yeah, I mean, it's a file. They're joint properties. If you look at our evidence on pages 8, 9, 10, and 11, you'll note that they are one economic unit, and you can see that the rents are recorded together. So in our mind, it was always one unit. So we breakdown was just to ensure that both notices were sent, and the city was aware that it's a one economic unit.
But can you explain to me why the request actually on page 18 of my submission specifically says at the 5th or 6th line from the bottom, we need the mailing address changed for the following 2 rolls. And of course it's 6500, which is 350 Northtown, and 6600, which is 400 Northtown. And then it goes on to say the owner has not changed only the mailing address. Thank you. If you were already receiving the notices for 400 Northtown, why go through a process of having the address changed?
Well, I mean, I guess I can put the question to Linda. I was just looking to see if she was here to answer that question. I didn't write the letter. I know that, and you know from your records, we've been working on 400 Northtown since the minute it hit the roll, and with the subsequent, all the supplementals on it as well. So from my perspective, we had 400 Northtown. I was working on it. I've never been engaged on 350. I imagine Linda was just trying to be ensure that both were in. She described the process to me, and of course, this might be hearsay, but she's saying that it was a stupid process for doing it to 311. But again, it is a question for her. I don't think anything turns on it.
Okay. And again, in that particular correspondence, if you do go to page, bottom of page 16 and page 17 of my submission, the request is to change it from on one of them in particular, is to change it from the old address at 6600 from a Hopewell in Calgary. When our notices were clearly going to 447 Portage, can you understand why that might have been the request for?
Certainly, Hopewell and Investors Group were partners on this venture, and some of the early correspondence came from Lainey Hicks in Calgary, who sent them to me, and that was in the early days of 400 Northtown. And I think on or about late 2019, the changeover occurred. And when I inquired further as to the nature of their relationship, it turned out that Hopewell wasn't so much a partner as they were a manager of sorts. I don't know exactly what they did for investors. Both titles are in Investors' name, though, and so one was sent to 447 Portage, and one was originally sent to Calgary. And the one on 400, I'm getting the 400 documents here, and never seen 350.
You also indicated that, or the indication is that the notice of change that I've got on page 13 must have been delivered to the city of Winnipeg. Who would have been responsible for delivering that? And do you have any proof that it was mailed? Is there any evidence that it was sent to us?
On your page 13?
Yeah, it's the notice, the generic notice. Like who would have been responsible for sending it?
Okay, the sender was Maurice Toutant, who's the director of real estate, and he's the person that would that Linda reports to, and that when I do need certain decisions made, he would be the person responsible for Manitoba's assets. He's an asset manager, I suppose. And he said it was sent by a regular mail, which is the same process the city used to send out their notice.
And did he alert you guys as to whom he had sent them to?
No, I don't have that information on the delivery.
Okay. And one last comment or question. You said that you pulled up the tax arrear information through our subscription program.
Correct.
And you don't have to be an authorized agent to access that information. As long as you're a subscriber to the program, you can access that information, correct?
Well, until recently, yes. You just had to pay your $11 and you could look at it.
So I could look up the tax roll or assessment tax information on any property as long as I was a subscriber to that particular service?
As I understand, that's no longer possible. In June, it was possible, and I did pull this up.
So it's not that Colliers or Ms. Mikluck had received a notice from the city as much as they had seen online through a subscription service that there was an outstanding amount of taxes, correct?
No, that was me who looked it up, because they're not in the business of looking it up. As you know, that the subscription service is part of the legislative requirement to show the roll, and so that's why it's available to anyone who's willing to look it up. And on occasions, when it becomes a matter of having to deal with it, did you see the notice or did you not see the notice? The guiding principle is the publication of the information in the newspaper that a general reassessment is happening. And they go, when someone goes to look up this information, the notice must go hand in hand with the knowledge that a general reassessment is occurring or there's been a public notice. It's not meant to be operated on its own in terms of the official notice, which is why these supplemental notices that we're dealing with were never part of the general reassessment. So there's no advertisement in the newspaper, whereas the 2022 was known to be a regular assessment and the general reassessment. This is why we have these affidavits and these problems. They're always dealing with supplementals, not the regular reassessment.
But just to clarify, you've obtained the information through a subscription service, not by virtue of receiving a notice.
No, I did in June of 22. And by the way, I did email you what I received. I don't know if it's included in the package of documents, but I was reading from it, and so you have it, and the board, if they want to look at it, they have it.
Thank you. That's all my questions.
McIntyre, any questions?
I have no additional questions. Thank you.
Mrs. Smith?
I have a question. Mr. Neufeld, I'm just wondering, does Colliers or your company have any processes in place other than the year-end thing that you referred to track themselves when significant issues have been dealt with? I think I would see this as a significant issue, just given the magnitude of the property. Does Colliers have a tracking
Yes,
system in place to know that requests have been dealt with in a timely and appropriate way?
yes, we do. We actually have 3 periods when we review. One is the fiscal year end of the property in question. The second is when the requests for information come, the questionnaires come. And lastly, when the tax bill comes. So each of these procedures, there'll be a checklist for the property manager to make sure that the file is in order. The issue with this particular property is we took it over, as you can see by the letter, in January of 2020, and we ourselves didn't, never had received any of the original documents because we never got the questionnaires. We never got the tax bills, and then when Linda did her review, I think that related to the fiscal year end of the property, noted that we had nothing on file, and then she began her process of trying to track down the bills in April of 2021. So it was a new property. It's a real short answer, but the rest of the properties we're reviewing 3 times a year. And I myself trigger the one on income and expense questionnaires. I go through that's my responsibility. I go through our entire managed properties, and I well, not me, but my assistant checks and says, do we have a questionnaire for each and every one of them filled out? And at that point, we will catch ones that have been missed. And we do it, had to do it quite often where we find properties that we're managing and we see no questionnaire, and we'll just grab a blank return off the internet, fill it in and send it in and say, we did not receive it. We do that probably once a year. On this particular one, we had no notice. So I would describe our due diligence as being over and above what's normally required, and it's true, we missed it as well on 350. But we did.
So the first opportunity after this notice went out back in December of 2019 was, when did you first notice this? Had it been changed?
It would be the fiscal year end. And the assessor has provided this in a series of emails in April of 21. Looks like April 19th. Sorry, the emails are in reverse order, so it's the back of page 18. That was the first request. That's when we got it.
I'm sorry, could you point me to the right page? Sorry.
This is the assessor's exhibit on preliminary issues on
Yes.
page 18.
Page 18 being the email chain?
Yes, that's the beginning of the email change, April 19th, 2021, when we noted that we didn't have notices in our property management file.
So the notice went out in December of 19, and you didn't notice until April of 2021?
Yes, and you can understand what the extenuating circumstances were at the time. I believe our office shut down mid-April of 20, and everybody worked at home. So in our case, our own due diligence was a little bit quicker. We would still be, but mind you, we would still be here debating this matter, and it'll just be the length of time that happened between the time we found it and they were sent out. It may not have been 124 days, it may have been 60 days or 90 days, but late is late. But so our own due diligence, when what happened is everybody was working at home, and so the teams, there's a property manager, assistant property manager, and an accountant assigned to each case. So, and this is just a comedy of errors. We were also in the process of being purchased by Colliers International, and all of our accounting services were being sent to Vancouver. So we had an extra linkage in there. And that's just what happened. That's not an excuse. As I said, late is late. It would have been if it was, we still didn't get the notice on time, regardless of when we caught it. As of I would say June of this year, or actually August of this year, we are actually up and running in our new location. And we have things a little bit more in order.
Thank you, Mr. Neufeld.
Hey, Mr. Neufeld, I've got a couple of questions. First of all, you indicated that the notice was in fact sent, but you don't have anything before us to show that in fact it was posted. Correct?
No, and we spoke to Mr. Toutant, and he just said he mailed it. I mean, that's the.
I understand you spoke to him. It would be nice to have Mr. Dupont's affidavit or something, but we don't have that. But anyway, besides that, I'm looking at the notice itself, and it says at the top 350-400 Northtown. It doesn't say 350 and 400. Now, someone looking at it very quickly would think that so maybe only pertain to 400 because others could be part of the address of 400. I don't think it's very clear.
Civic addresses hadn't been handed out at that time, and we didn't know if they'd be merged or separate entities.
Yes, that's why you only have one tax roll.
Yeah, we don't. In 2019, we weren't sure how they would end up being. They had been subdivided a few years prior, but we weren't aware. It was common ownership, and you can see, as I mentioned, page 8 to 11 in our brief. One economic unit, one statement. We weren't sure what direction they were going to go in on it. And so I believe he just wrote it that way, probably deliberately unsure whether it was a plus or a dash to be included.
Well, it could have been clearer. Couldn't have said 400, 350 and 400?
Well, I suppose.
Ask if I could have said that.
Yeah, I suppose.
The answer isn't the answer. I guess the question I think could be answered by yes, it could have been done that way, and it would have been better, correct?
It would have been. Yes, I think it would have been better.
Okay, that's my questions.
Just if I may add, Mr. Chairman, just because there were a number of questions as to where's the evidence that it was sent. I think clearly it was sent. And clearly it was received based on the fact that 400 Northtown was changed. This is more a matter of summation. There can be no question on the evidence here that this was sent and received by the city and processed. What is clear is they didn't process it for 350 for whatever reason. Maybe we're all speculating here as to maybe it's the form of the notice here, maybe it's an error of the city's administration, and none of us in this, on this hearing will be able to say for certain. But I think for one thing is clear is that there was an intent to have the notices changed to Colliers. That happened with respect to one property, not the other, and they didn't receive these notices. They were in tax arrears on 350 Northtown. That can easily draw the inference that because they weren't receiving, the proper entity wasn't receiving the notices. So the question becomes what the board wishes to do with it. And I think at a basic principles of fairness, the answer to that in my submission should be clear, that we should deal with the applications on their merits. And frankly, I would suggest the city should be encouraging that themselves in the circumstances of this case, in fairness to the taxpayer. So those are my submissions.
Thank you, Mr. Corcoran. Do you have any submission?
Yes, I would. I would like to just suggest, or I would like to surmise that the applications received long after the 20-day period attached to the notices. The affidavit is from an individual who did not receive a notice, let alone the original notice it wasn't addressed to. There's a suggestion that the city was in receipt of this address change information because we changed it on an adjacent property. The email chain requesting the address change demonstrates otherwise. I don't think it's as clear as has been stated that we received anything. The address change that they're pointing to is a generic letter that is not addressed to any individual department or any individual vendor. We have not received it, had not received it until April of 2021, long after the application period for these notices would have lapsed. So it remains our position that the application on these two supplemental assessments was received late, very, very late, in excess of 195 days late, and they are invalid and should be dismissed.
Thank you. We'll take an adjournment so we can discuss this matter among the board, and we'll have our decision shortly. Thank you. We'll reconvene the meeting at this point. Thank you, everybody, for waiting for our decision. We have made the decision. We've accepted the argument of the assessor, and based on the evidence that was provided, and on that basis, we have determined that the applications for 2019 and 2020 applications are not properly before us, and we're not going to hear those matters.
Okay, so we will continue to item 5.
And we'll continue on to item number 5.
Sorry, may I just ask a question, and or Mr. Mercury might, whether or not we're going to get a written reasoning?
You'll get notification of how this matter has been dealt with from the board.
Sorry, you are muted, Mr. Neufeld.
No, we know it'll be written notification. I was just wondering if there was going to be a reason why it was, and I don't know if you're obligated to or not, but just a question.
I mean, we could certainly write a decision, but we're not, that's not our mandate. And we basically, on the evidence that we hear, make decisions. Anything that does go before the court on an appeal by any party, obviously everything will be coming up again. And the court will hear the evidence that we heard and will give written decisions, I'm sure, on the basis of the evidence that you provide them.
I think that the reason for the request, Mr. Chair, is that the remedy for the applicant in this case would be a judicial review application of the Board of Revision, and paramount to the process is the reasons of the Board of Revision for coming to the decision. And so in these circumstances, I think the reason for Mr. Neufeld's request is that there has to be a record. It's not a hearing de novo, if you will, before, unlike a liability appeal, for example. This would be a separate judicial review appeal process, which would require scrutiny of the reasons of the board. And so that is the reason for Mr. Neufeld's request. But I think maybe as a practical solution, I can speak with Mr. Neufeld and the applicant in particular and see if they wish to receive written reasons. And if so, then we would advise the secretary of such, and then maybe you could determine the matter at that point. But I don't know that we need to spend much more time on that at this stage.
Okay, thank you, Mr. Mercury. We'll see what transpires.
Thank you.
Okay, we'll proceed on then with number 5 on the agenda, which is the 2021 application, 350 North Town Road. And Professor can go ahead at this point.
If I may, Mr. Chairman, just clarify that for 2022, which I believe is the application you've moved on to.
Sorry, 2022. Sorry.
The classification and liability has also been put at issue, which we would submit as the onus of the applicant. How do you wish to proceed with the quantum conversations first, or shall we proceed with the class and liability?
You know, on the basis of the application, correct. The applicant should go first, Mr. Corcoran, you're right. And so, Mr. Neufeld, you can proceed.
Yes, thank you. I think Mr. Mercury was going to take the lead on this.
Yeah, if I could, and Mr. Neufeld can supplement as may be necessary, Mr. Chairman. If you have the Collier's brief, I'll be just referring to some documentation there, and then also the assessor's brief and the rebuttal information we'll touch on. Just by way of background, there's a number of documents in the brief that aren't all, of course, related to the liability and classification issue. But if you turn to page 55 of 105 of the brief, if you have that, so what you'll find there is a letter from my office to the Assessment and Taxation Department dealing with the there are two tenants in this complex that in our submission clearly qualify for the exemption under section 23 sub 1 sub D of the Municipal Assessment Act, and they are the Musearch School of Music and an entity called Code Ninjas. I'll touch on both of them in turn, but the general process, as the board may be aware as to how we deal with exemption matters, is typically we will send a request for review to the Assessment and Taxation Department, and that can be done at any time when information comes to our attention. And so this is what we had done in June of this year. It had come to our attention that these tenants were operating, and upon a review, it was determined that they, in our view, would clearly qualify for the exemption, and I'll go through the reasons for that. So that you see the letter that has gone to the Assessment Department. I will say that there has been no substantive response at all to this letter until such time as we received the brief in this matter. So because of in light of the fact that there was a supplemental assessment issued on this property subsequent to this letter, that is why classification liability is now before the board. In a perfect world, I would suggest that this matter would play itself out, and we would have the assessor's position and consider what if anything needed to be done from there. But unfortunately, the assessor chose not to respond to this letter. Maybe a matter of resources or otherwise, but I'm not sure why they didn't respond. So the application is now before you. So just by way of background, Musearch, this is at 350 Northtown. There's a copy of the lease. I don't know that it's necessary to go through all the provisions of the lease, but they occupy 1,390 square feet in the building. This is a music school. And we've provided a number of supporting documents. It should be apparent and clear that this is a music school. The section that we're relying on, of course, is 23(1)D of the Municipal Assessment Act, which states that property that is owned by and used for a seminary of learning is entitled to a school tax exemption. There's no debate there. There's no debate that Musearch qualifies as an owner under the Municipal Assessment Act as a leasehold owner. The only question is whether this particular operation, this entity, this business, if you will, qualifies as a seminary of learning. One would have thought that this would be obvious. It's a school. It's a music school in particular. So we've included some basic principles. This has come before the board on many occasions. In fact, the assessment department has recognized various seminaries of learning as qualifying for school tax exemption throughout the city of Winnipeg, appropriately so. And we've previously dealt with them in court decisions. We've dealt with them in prior board decisions. And so it is, I must say, a little bit surprising that we are dealing with this again today. But the basic principles you'll find at page 57 of the brief, and this is in our letter to the assessor. Basic principles: seminary of learning is a place of education. In this particular case, this is musical education. The instruction given need not approximate that given in universities. So it is not only colleges and universities, for example, or technical colleges that are entitled to the benefit of the exemption. In fact, there are separate exemption provisions for universities and colleges in the Municipal Assessment Act. Next, the third criteria is whether those in attendance at these institutions fulfill better and more effectively the purpose to which they have dedicated themselves. Next, it has to be a school in the broad sense of the word. So educational activities conducted there must not be a sham or a cloak to cover non-exempt purposes. I don't think there's any suggestion that that is the case. To determine whether it's a bona fide school, you can look at a number of factors. They don't all have to be present, but the presence of students, physical facilities, teachers, or instructors, and a curriculum designed to further the advancement in life of those in attendance are relevant. And clearly all of those boxes are checked. You have students, you have physical facilities, there's musical instructors, teachers, and there is a curriculum, of course, for various these programs. This is not a drop-in center where you're just playing musical instruments. We've included in the material various certificates and awards that are handed out to the students. Next, number 6, the dominant or primary purpose of the institution is educative. The fact that non-ancillary activities or alternatives are conducted there does not detract from the purpose. It doesn't have to be used exclusively for educational purposes to maintain its tax-exempt status. We've cited the Law Society of Manitoba case. So the Law Society building, formerly at 219 Kennedy Street, was deemed to be a seminary of learning in the broad sense of the word. The Law Society, of course, carries out many functions, education being, however, a dominant one, and it was deemed to be a seminary of learning. I have noted here in the letter that the city has, in fact, granted a school tax exemption to at least 2 other music schools that we've found. Tabor Music School on Henderson Highway, very similar in operation to what MusiArc is offering. Essentially, it's the same type of school, just located in a different area of the city. And that was a matter we handled, I believe it was last year, and the assessor consented and agreed that, in fact, that entity was, in fact, exempt from school tax. So if you scroll down in the brief, we've included a number of excerpts from the MusiArc website, and you can see just, if you go to page 61, you can see the various instruments. They teach instruction with respect to these instruments: piano, guitar, vocals, percussion, violin, cello, double bass, wind instruments, etc. If you scroll down to page 64, there are trial lessons, there are private lessons, music classes, study packages, special lessons, various student opportunities, and so forth. You can see the programs, the times when they are run. This is page 67 and onwards. And so then there are, so that's MusiArc. If you, and I'll just pause there on MusiArc. It's unquestionably a music school and qualifies. As I read the assessor's material, it is a little bit confusing. Again, this is the first time that they had, in fact, even responded to this in any substantive way. I'm not sure why that was the case, but they appear to be taking the position and that the program, there's not enough information to satisfy the department that this is, in fact, a school as the assessment department defines it. I'm not sure where they're coming up with that specific definition, but I'm just looking at the assessor's material. And again, prior to this, nobody had contacted my office to even request any additional information. We, in fact, had thought it would be, there's more than sufficient information here. Sorry, just let me back up and I will find the assessor's brief. So there doesn't appear to be a dispute on the basic principles to be applied, but they suggest that it should include a regular course of study and fixed standards. Well, I'm not sure where they're getting at what they mean by that, or where that is in the legislation, or where that is in the case law, is that it doesn't exist. Then you see paragraph 10 of their brief, that there was, they cite as an example the Manitoba Board of Education of Royal Conservatory of Canada's programming qualifying towards high school credits as broad providers of that program within the understanding of a bona fide school. USARC is not listed as a recognized provider of Conservatory of Canada curriculum. Again, I have no idea why the assessor would rely on that. That is not in any way, shape, or form a requirement of the legislation. You'll find it nowhere in the case law. In fact, the leading case out of the Supreme Court of Canada made it very clear, in fact, that you don't need a fixed curriculum. And that's the evangelical case that we have provided to it's part of the rebuttal material that was submitted, and you can find that in Collier's rebuttal material. If you have that document and you go to page 21, Worldwide Evangelization of Crusade of Canada. This is the leading case, routinely cited, and you'll see the portion of the brief, page 21 at the bottom. The word seminary, standing by itself, has no fixed legal meaning. It's not a term of art, and its primary meaning is simply a place of education. And the proper way to decide whether the Act applies is not to compare the method of instruction with that given in other institutions falling within the description of seminary learning, but rather to inquire whether those in attendance learn to fulfill better and more effectively the religious purpose to which they had dedicated themselves. In that particular case, it had to be a religious seminary of learning. They've removed the word religious in the present Act. It doesn't have to be only religious seminaries of learning. It's all seminaries of learning. And a formal curriculum. In fact, if you can see at page 23, third paragraph down, while there is no fixed curriculum, this is the Supreme Court of Canada noting there's no fixed curriculum, but there were no examinations, in fact, and the length of time the students attended was at the discretion of the staff, and they can leave and enter the missionary work when the staff feel they are entitled and qualified to do so. And this qualified for an exemption, and that case has been followed for 60 or 70 years. They say learning to be better missionaries is no mere byproduct or chance. These persons living and working together in this establishment is the primary purpose of their association. So if we look at the present situation, you have students of all ages attending the music school, clearly to advance their musical abilities, and in some cases to be perhaps professional musicians, but in other cases simply to advance in life generally. So they unquestionably tick off all the boxes. If this were a question of the assessor requiring more information, they've had several months to ask for it. We in fact invited the assessor to ask any additional questions they may have. They did not do so. So that covers MusiArc, I believe, although I should note in the rebuttal, in response to their suggestion, there's not enough information. We gave more information. You can see the various awards and certificates at the top of the rebuttal brief. You can see the application that was filed for Tabor Music School, which I had mentioned earlier. That's at page 8 of the brief, which was virtually identical, almost the same size, in fact, where that exemption was granted. We have also included the material there. You can see the assessment, page 15, you'll see the taxable school exempt portion, that's Tabor Music School. And then at page 16, we have these are from the websites of the 3 music schools: Tabor Music School, Winnipeg Conservatory of Music, and the subject property Musiark. And if you look at the descriptions of the programs generally, they're essentially describing the exact same thing, albeit in slightly different words. Tabor, they're dedicated to teaching music and to offering high quality programs and lessons. The Conservatory of Music is an educational institution that provides quality private and group music education to students of all ages and stages of musical development. And Musiark describes themselves as a leading provider of professional music education, providing innovative music lessons from classes from beginner through to advanced for children, teens, and adults. So there's no material distinction between these. I've also included the Board of Revision orders. In other educational institutions which we've been involved with, the Winnipeg Construction Association, which does a number of things but has a large educative component to it for its members. The Board of Revision back in 2015 granted the exemption for the Construction Association. You can see the board order there. The Manitoba Real Estate Association at page 19, due to its educative functions, was granted the exemption. There are several others. I've included the Supreme Court of Canada case. I could go on. The Law Society, the Association of Engineers, the Association of Dental Hygienists. There are schools for hair schools. There are English second language schools. There are all types of seminaries of learning that have been recognized and accepted by the City Assessment Department. So we are a little bit puzzled by this one. Moving on to the second tenant that would, in our view, qualify, and that is an entity called Code Ninjas, which is 2,332 square feet in the building. I should pause to note that Mr. Neufeld ultimately can give you a valuation breakdown in terms of the proportionate amount of the exemption to which the exemption would apply. So I won't deal with that other than just on a principled basis what we're dealing with. So let me just locate, if you have to go back to the original brief on the Collier's brief. And so I'll just direct you to the Code Ninjas. Essentially, it is a, sorry, let me just bring it up. Starting at page 69 of the brief. You can see this just general introduction. Code Ninjas is the world's largest and fastest growing kids coding franchise, which with hundreds of locations. Kids learn to code while building their own video games. There's gains problem solving, critical thinking, and STEM cells in a fun, safe, and inspiring environment. Then there's a FAQ section where you can learn a little bit more about what this is. You can see if you just go down to page 71, at what ages does Code Ninjas teach? Programs for kids ages 5 to 14. And then a better description below why this is deemed to be important, particularly to the younger generation. Coding has been called the literacy of the 21st century for good reason. Just like math, science, and literature, coding is a key aspect of understanding our technologically advanced world. The huge need for a generation that not only understands technology, but how it works. And regardless of whether your kids one day pursue a career in coding, Code Ninja teaches them confidence, logic, resourcefulness, and problem-solving skills that will serve them for the rest of their life. And you'll note at page 72, essentially what this is. They say, well, we have computer education in school. Why do we need coding? They say this is due to the fact that schools are often under-resourced and unable to offer the sophisticated ongoing coding curriculum that kids need. So there's a coding curriculum that is followed and taught to kids of various ages. You can see the curriculum that is there, and that is the information we have with respect to Code Ninjas. And I would suggest, I'm not going to repeat all of the the preconditions for a seminary of learning. But clearly, it's not a school in the traditional sense of the word. It's obviously not a public school or a private school, or certainly not a college or university, but it is a place of education. And it is not the educational component here is front and center. It's not used to cover up some non-exempt purpose. It's front and center in terms of what they do. So that is my submission with respect to the liability and classification issue of the two tenants. And I'm certainly open to questions from the assessor or the panel.
Mr. Corcoran, any questions?
Sorry, I began speaking and realized I was absolutely muted. Yes, I have some questions. The music art. So to get to the issue of curriculum, first of all, you pointed to Supreme Court of Canada decision from 1959 with reference to the curriculum and no need for curriculum. And then we also, both parties rely on the 2011 affirmation of the Court of Appeal decision at the Law Society, where they actually list the six premises or six tests for seminary of learning. Is it plausible that in 2011, the Court of Appeal in Manitoba understood that Supreme Court Canada decision when they laid out those six tests?
Absolutely, they would have understood it. It's cited in it's actually the Court of Queen's Bench decision in the Law Society. The Court of Appeal quickly dismissed the appeal, but the Court of Queen's Bench is the more thorough decision, and they relied on, I don't have it in front of me, but they certainly cited the Supreme Court of Canada decision as the binding authority, and they followed it. There's been several other decisions outside of the Law Society case, but what they list there is these aren't factors. What they say is there's a number of things that you can look at when you're considering whether it's a seminary of learning, and these are some examples of what you can look at. Is there a curriculum? Is there presence of staff? So forth. But there's certainly not. It's not like checking the boxes. Like any case, you have to look at it holistically in terms of is this a place of education? Many institutions, as we know, certainly in the last couple of years, are going to online learning and virtual education experiences. So you may not actually have the physical presence of teachers and staff and a full staff at any particular time. However, if that institution is still used as a seminary of learning, it qualifies. So I'm well familiar with the Law Society case, having acted as counsel in that matter. So yes, I can say that the Supreme Court case was the first and most important decision we relied upon.
So then when the Law Society says to determine whether the institution is a bona fide school, it requires the following.
Well, it doesn't say that. And so just to paraphrase, I'm just trying to find the letter. It says to determine whether the institution is a bona fide school, the presence of students, physical facilities, teachers or instructors, and a curriculum designed to further advancement in life of those in attendance are relevant. It doesn't mean you check off the box and so forth. First of all, there is a curriculum here in terms of how do you want to define that. The Supreme Court of Canada case, however, I just read to you, which was the basis of the Law Society decision, noted there was no curriculum. So this is not a case where if you don't have a formal manual of some kind, you're automatically disqualified from being a place of education. Places of education can be places where you learn by experience and practical teaching, not necessarily theory, for example, or fully structured courses. It's you have to look at it holistically, and that's exactly what the court said in the Law Society case, Chief Justice Joyal. So, and again, if there was certain information that the assessment department required further, in terms of we thought it was self-evident, but as I said, that there was unfortunately no communication from the assessment department when we sent this. And typically, as in the past, Tabor Music School, for example, when we had submitted that one, there were maybe a few questions that either the assessor or legal counsel had. We were happy to provide any information that they needed, and it was dealt with on a consensual basis. So here we are. We're in a board proceeding, but one would have thought that if there was any clarification required, we could have dealt with this certainly in advance.
I'll comment on that in a moment. Just to further with my questions, Music Arc, in your understanding of what they do they provide Royal Conservatory programming there? Do you know for certain? Or
Royal Conservatory programming? Well, the Royal Conservatory is a different institution altogether, and Mr. Neufeld may be able to speak to that separately. Certainly, it prepares students for other musical schools or institutes, including the Royal Conservatory. And so it is certainly providing a level of education for them. But again, I am puzzled by the reason why that particular institution is flagged. Because it's not the benchmark. Go ahead, Mr. Neufeld. You can speak to that.
Yes, we had seen that, and I can speak to this myself, or I have a witness here who could speak to it as well. My daughter, who went through this program, and I drove her to a lot of these things. So the Royal Conservatory of Music is sort of like an arm's length test provider. The people who train people for Royal Conservatory of Music have to teach them both practical and theory. And then when their teacher judges them ready, they make application to the conservatory for their testing. And then the conservatory awards the degree. There's no really such thing as being on their list because, for example, in our particular case, my children's music teacher taught out of her basement and had no affiliation with any company. But my children were then went to the conservatory and did their exams, as did my wife. So it's not, I think the test here isn't, are you on their list, is does the provider, are they able to teach theory? And you can obviously see from what they do, they teach theory and practice. This isn't hearsay, but I do have someone who's been through this program taught by somebody who was not on any improved list. Our teacher had been doing this for 30 years, taught my wife when she was a child and taught my kids later. That's the way the system works. They prepare and get them ready for the conservatory test.
Okay, thank you. And beyond the website screenshots, is there any material to outline perhaps the theory and or practical?
Absolutely. And do you want this from me or do you want this from my daughter? Because she lives half a block away and took her children in to inquire about the programs to determine that it met those standards.
I'm just asking in the material that's before us today or that was submitted to us with this application.
As part of our review, we did look at the site to determine that it would fit the standards. She's aware of the program and brought her sons in to determine that it was something that met the Royal Conservatory standards. So our own due diligence indicated that that the children would be received. And on their website, I believe it does say something about preparing students for conservatory.
Is that in the material here today or in the application to us?
I thought we had it in there. Okay, on page 64 and 65, actually, what you do is, it was on one of these links that we found out. Here, on page 65, under special lessons, for students who would like to apply for the music faculty in university and college, you need extra practice and guidance for the interview and entrance examination. So that's for the university side of it, and we should have provided that page as well, but on that page, it does talk about conservatory as well.
Thank you. And on the Code Ninjas tenancy, likewise, is there reference in the material provided here beyond these screenshot, anything that outlines the objectives, learning objectives, the what is taught during the sessions there that we could approximate as a curriculum, other than the one paragraph I see here?
I think it's fairly clear that they're teaching computer coding, like the specific granular detail of how they lay that out and how, the mechanics of how they teach it. We don't have that information, nor do I think it's particularly relevant. It's a school. It's educational content that is being provided for computer programming. So we didn't think it was necessary to actually, nor have we in the past, produced details of the precise programming that is taught, other than a general description.
Sorry, bottom of page 71. Regardless of whether your kids one day pursue a career in coding, Code Ninja teachers teach them, et cetera, et cetera.
Right. So there's a general description of what's provided there.
I have no further questions. Thank you.
Elizabeth, do you have any questions?
I have no questions, thank you.
Mr. McIntyre, do you have any questions?
I have no questions, thank you.
And I have no questions, thank you.
Sorry, Mr. Mercury had mentioned earlier that we hadn't given you the ratios of it, and I was just going to give you the percentage of the total space that was occupied by each of these two entities for the application of the exemption. Musi-Arc is 2.44% of the rentable area. Code Ninjas is 4.51%, and I'm just doing this by square foot.
Thank you.
Our request would be apply 6.95% of this as school exempt.
Okay, so that completes the questioning. So the sister can go ahead with Ms. Evans.
Thank you, Mr. Chair. On the matter of classification liability, I'll be doing the presentation, and then when it comes to the quantum piece, Marina will be doing the valuation piece. And I'll keep my comments on the class and liability concise. I do acknowledge that indeed the applications were received by the City of Winnipeg in June of this year, 2021, relating to these two particular tenants at this location. And I'll acknowledge that the request was for a school tax exemption under section 23(1)D of the Municipal Assessment Act, as described by Mr. Mercury. And we both subscribe to the same widely accepted seminary of learning criteria that he outlined as defined in the Law Society case. Perhaps the city looks at it more of as a checklist and a series of requirements in order to be considered a seminary of learning. much less so it would seem than Mr. Mercury does, or more so than Mr. Mercury does. And on that basis, at the time of the writing of the document that's before you, we had not confirmed the curriculum for either of these organizations. And certainly the decision in some of the other music school cases was tied to the recognition by the Manitoba Board of Education of the Royal Conservatory of Canada's program. So if that's the case, if Music Arc is providing Royal Conservatory programming, then I'm perhaps that absolutely qualifies. Just at the time of the writing of this material, that had not been conveyed to us in the material we'd reviewed to that point, and it wasn't clear to us in the material we reviewed on our own. Code Ninjas, likewise, again, this idea or concept of a curriculum. And programming is one thing, curriculum, where, as Mr. Mercury pointed out in my submission in paragraph 9, it's our understanding that there's a regular course of study and fixed standards, which is why the reference to the Royal Conservatory is a measure. And it wasn't clear to us from the Code Ninjas operation that there was a course of study or fixed standards, outside of what might be considered programming. So that's where our hesitation is. It's on the lack of curriculum, or what we perceived at the time of this writing as a lack of curriculum. And I didn't see anything in the material here that was robust in terms of a description of curriculum. Some comments as to the learning objectives or what they intend to achieve, but I haven't seen anything that's a course of study or a program of study where you would advance through levels, which is where our hesitation was on that matter. And really that's where it's at. Part of the applications before this board were filed 5 days after the application for the exemptions was submitted to the department, and the resources, as alluded to, don't always allow us to get to these things as quickly as possible. And when there's a pending matter before this panel, to create a change and issue a supplemental that supersedes and it renders the application before this panel moot is something that we are careful of. So that's the end of my submission. I'm open for questions.
Thank you.
Just a few.
If you ask any questions, yes. Or Mr.
Just a couple of questions. So, Mr. Corcoran, you do acknowledge there was no follow-up for a request for additional information on either of these tenancies?
We did our own in-house research leading up to the application, this particular proceeding. Yes.
Okay. You mentioned that you used the Royal Conservatory programming as a standard. I'm assuming, Mr. Corcoran, that is just an internal methodology. It's not based on any case law, and it's not based on anything you find in the Municipal Assessment Act, is it?
Under the premise that when an exemption is requested, it falls to the applicant to, the obligation is on them to put their organization squarely within the meaning of the exemption. We rely on what's been submitted to us and go through a review process. When we review something like what you pointed to as Tauber School, and we see a curriculum, we see high school education credits being granted for the program of study. With that understanding, they squarely put themselves under the as qualifying for that particular exemption.
What I'm asking about, yeah, sorry, go ahead.
We at this point in time on this particular file, we're still in in that review stage to understand exactly what it is that we're dealing with here.
So you're still in the review stage. You knew this was coming for hearing. I guess my question is why not reach out to request additional information, particularly when you know there's a hearing coming up?
The evidence that you submitted didn't add anything to the information that we had. We weren't sure that there was, but it is a good question.
Okay. You would agree generally, Mr. Courtfield, that broadly speaking, that these two tenants offer educational programming, correct?
I don't disagree that there's an educational theme. Yes.
Okay. In fact, they don't do anything other than education, correct?
Code Ninjas does birthday parties.
Okay.
But
the primary purpose is educative, correct?
I would concede that the music arc perhaps more so is easier to see that than Code Ninjas.
Right. Okay. Those are my questions for you, Mr. Courtfield. Thanks for certainly being forthright in terms of where you were at in the process. The only thing I would offer, of course, just generally is to the extent that the assessment department requires any additional information at any time, they're always welcome to request it, as you know. Those are my questions. Thank you.
Thank you. Ms. Lisbeth, any questions?
No questions.
Mr. McIntyre, any questions?
I have no questions, thank you.
I have no questions either, so we'll make our determination on the basis of the exemption, and we'll let you know what it is very shortly.
Thank you.
Oh, right, sorry. Wait, we have to go off.
Session to members.
We have to hear assessment.
Don't we still have to hear their value arguments?
Okay, I thought we were making it.
Oh.
Okay,
That decision usually gets made in camera at the end.
okay, that's fine. Then we can do that. You know what? Then okay, we'll make this our decision at the end, as always. And I'm just wondering, based on the time right now,
11:37.
yeah, 11:37. If it might be a good time to take a break and come back to it.
Sure.
For this. So maybe take a break for half an hour or 45 minutes.
Yeah, 45 minutes.
Okay.
Are you okay with that, Mo?
And everybody's good with a 45-minute break now? So we'll reconvene at, let's say, 12:15, 12:20.
Okay.
Okay.
Sure.
Okay, we will resume the session that we had started this morning, and we're dealing, I guess, with 350 North Town Road for the 2022 assessment. And Ms. Tenerwara, you can proceed when you're ready.
Thank you. Before she proceeds, may I ask something on a point of order? It'd be very quick.
Go ahead.
Yes, and I'm going to apologize in advance. I don't mean anything personal, but I have some concerns, and I think we just want to get them down for the record. One of the issues we're going to debate is the concept of non-recoverable expenses. And non-recoverable expenses, with the exception of the city of Winnipeg, are treated differently, and they have done it by way of policy rather than by market. And Mr. McIntyre was a supervisor, and I just wanted to ask if he was involved in the creation of this concept in any way.
No, I have not been involved.
Okay, I have to ask for the record. And the second question is, and the last one is, for some reason we have the board revision manual, and it's on page 42 of the manual, and it asks about conflicts of interest. And so in reference to that, have you at any time outside of the board of revision discussed this matter with anyone on the non-recoverable expenses?
No, I have not.
Thanks. Sorry, I apologize. I think it's appropriate to ask former assessors on this matter. Thank you. Sorry.
That's fine. Okay, we'll now proceed. So again, Mr. Assessor, you can proceed when you're ready with your brief on dealing with 350 Northtown Road 2022 assessment. Item number 5 on the agenda.
Thank you, Mr. Chair.
So you can go ahead with your evidence.
Okay. File number 21225. Property address 350 Northtown Road. Roll number 0309 1626500. Property owner is IG Investment Management Limited. Property valuation roll year is 2022. Reference date is April 1st, 2018. Property was assessed 18,727,000. Property used as a neighborhood shopping center. It contains 5 buildings and 15 business premises. Property built in 2017 to 2018 period of time. My page number 2, it will show the development plan. It will show all the buildings, 5 buildings in there. The oldest building built in Tim Hortons and the veterinary clinic, and all the other businesses moved on within the period of 2017 to 2021. The latest tenant moved in this year of March. My page number 4 will show the pictures. It shows the all of the units. It shows the veterinary clinic, Shoppers Drug Mart, and the CRUs. And those are Google pictures from the street view. Page number 6 is the comparables. Those comparables came from 400 Northtown Road. It's adjacent property, and all the comparables showing lowest is $31 to $43 per square feet. Those are the very recent, very close proximity new units and comparables. My page number 7 is a income value calculation. You will see the difference in final value in first page and this page. The property value, the time we send the original assessment, the value calculated 18,727,000, but currently it was calculating 18,524,000. The reason why for this difference, because the time we sent the original assessment, all the units were not occupied. We did not license the business for all the units. And once we do the valuation for the business of assessment, and its rates change here and there, but average rent is the exact very close, but our original rent was $27.92 per square feet. My new valuation showing $27.55 per square feet overall. I think applicant's brief, Mr. Neufeld's brief, is showing it's $27.74 per square feet. At this point, applicant and me are not, we are in the same page for the rental rates. I just mentioned those are market model-driven rents we applied for the valuation. And the vacancy rate is 4%. We use the market vacancy for this property because at the reference date, this property is still under construction. Some buildings were constructed, some buildings are under construction. Under construction, we use market model-driven market vacancy to contemplate the vacancy rate, because none of the vacancy all the vacancies post-reference, and at that time, it's units were leased out, some units were leased out, some units were under negotiation. So we don't know chronic vacancy in here. We applied market model-driven vacancy rate. And expenses is 2%. It's model-driven expenses rate we applied. Cap rate is 7.15, which is model-driven too for the neighborhood shopping center. My new valuation, 18,524,000, which is different than the original value, but we are okay to accept new value as the 18,524,000, which is 1.8 difference between the original valuation and calculation. This happened because of the active system and rates change here and there. And I did provide the income expenses mailer lately, but those income expenses mailer mostly post-reference because all the information at that time, only 2 units for the reference period, only 2 units were occupied for the exact reference date. Not only 2 units, some units were occupied, some are under construction, some are under negotiation. But I'm not going to talk anything about the income expenses mailer, but all the rents are model driven, and me and Mr. Neufeld are very close. And actually, we are using lower rents than Mr. Neufeld used for this unit. That's all my presentation. Thank you, Mr. Chair.
Thank you. Mr. Neufeld, any questions?
Yes, I do. Firstly, what was the file number you read on this?
21225.
225. I don't have 225. Is it the same as 21385? The presentation?
Actually, Mr. Neufeld did not submit for brief for this particular file. I don't know why. I only received file number 21384, 21385.
Yeah, but they're all the same year. That aren't. Is that not correct? That's all I was wondering. 21385 and the 225 is the same reference date. Okay. All right. Okay. And I don't think there's an issue here. I don't think we received it, but it looks like I was reading the same information under 385.
Excuse me, Sniffer. We sent three briefs.
Okay. I'm not. Just like before with the notices, sometimes they don't always come, but in this case, there is no issue here because I do have the information and I'm content. But I just want to make sure if they weren't the same. But the numbers you described all seem to be as presented in 385. Okay.
Because it's the same reference here, right. I sent the 3 briefs.
Okay, good.
Okay.
Now, this, of course, is new construction, correct?
Yes.
And it's typical that new construction doesn't get absorbed immediately. Is that a fair statement?
At this property, as of today, it's all absorbed.
As of
right now, it's all absorbed by the tenants.
2020, and is that in your report?
I didn't get the question.
Is this information about the current absorption in your report?
No, but we inspect the property.
Okay, but you're saying that verbally now, but I heard you mention something about the post-reference material on the mailers, but you didn't submit that, did you?
I sent the brief. When I print the briefs, somehow I did not attach my income expenses mailer. It was removed. Okay. I sent my income expenses mailer second day. It is kind of a day late from the original submission. I think you might receive that.
Are they before the board then? I was just wondering if there was some information I had missing. Does the board have a secondary submission?
They do, and it was also shared with Bram on October 7th.
Okay, so just give me 30 seconds here. Graham, do you have that?
I can forward it again if you prefer.
But it's the exact same material you attach in your briefs.
That's yeah, that's all I wanted to see. So, what? Yeah. No, not in ours, but in the assessors. I don't have it. See, what I have attached in mine is the rent roll as of May 31st, 2020. Is that what you're referring to?
What's the file number you open?
I don't know. But we only had the one for the 2020.
We sent two.
Okay, let me just. Supplemental north down. Yeah, just sorry about that. I thought
no,
all the information here and okay, I have 225 here. Thank you. Sorry about that. And
that's okay.
And then you sent classification and liability and assessor brief late. Okay, so this is income and expense mailer for 2018, and then as of 2019. So this is what you're presenting is mailers from 2019 and 2018. Then that's what you referred to.
Yeah, that's what the same mailers you have in your briefs, but all of the information are post-reference. Some pre-reference, some post-reference, the way it's sent to us. That's what I mentioned.
Oh, okay, and in that mailer, I'm just looking at the post-reference mailers, and it does show considerable vacancies, does it not?
These properties are not vacant because those are under the construction period. We don't consider those ones as a vacant units. This is the construction period. Because
that's page. When was construction complete?
This construction, this building, it started in 2017. It's go to 2018, and I think 2019 also the construction was happening. Some interior alterations and stuff. Even 2020, some interior alteration was happening.
Well, interior, of course, but that's not the building. Your front page says 2017 to 2018.
Because we put the building date, but we put in the permits taken. That's the building date. But
okay, but as of April 2019, or sorry, May 2019. Which is a year after you said it was finished, you've got there. It's still showing significant vacancies, is it not?
It's not a vacancy. It's just the construction and lease up period. It for the brand new properties, it takes some time to lease up. But certainly. It's this property within the 2 years, it's all lease up.
But during this period of lease up, which is normal for new construction, that's what I asked you earlier. Does not it
yes, it is normal, common. But it's not the occupant vacancy.
So out of the standard 2-year cycle, you could have one entire year of high vacancy that filled up in the second year. That's is that what happened here?
But the brand new properties, vacancy rate we have two things to consider. One thing is as of the reference date, economic condition. Vacancy rate goes to the economic condition as of the reference date, and the physical condition to the building as of the roll year, January 1st, 2022. But the condition of the economic condition, it's under construction. It's not chronic vacancy.
Okay, but on that basis then, in 2018, the vacancy rate was 0 then, wasn't it? I mean, 100%. It was completely empty, correct?
It's not completely empty because the Tim Hortons move in and the veterinary clinic was there. I think medical clinic was there and Shoppers Drug Mart was there. It's not completely empty.
Not completely empty, but it was a very, very high vacancy in 2018.
Some units are under construction. It's the majority of the units are under construction. That means the interior finish or tenant fit ups or anything. Something happening, but it's not occupied by the businesses.
Now, I'm not trying to be argumentative here. I just want us to make sure we're talking about the right thing. But this building wouldn't be one where you would necessarily look at the market year for the vacancy. You're looking at an absorption vacancy, are you not? Like, how long is it going to take to fill up after construction is done? It won't be a market driven from 2018 or that actually occurred in the building, but you have to just consider a lease up period, do you not?
We do, but it's not a vacancy. It's not the chronic vacancy, but it's the unfinished units or something like that, but it's not the chronic vacancy.
Well, for example, on page 46 of this is post reference, and it's just for theoretical here. I'm looking at building 500. You'll note that the first number indicates the building. So you have Bridgewater Medical Center moved in October 2017, and going right to the bottom of the list, Bubble Tea, January 2019. But there are, at this time, 3 units that have been vacant since entry: 550, 560, and 570. Now, are you saying that building wasn't complete?
I'm saying the building was complete, but it could be the tenant improvements or the tenant fit ups or something happening, but it's not occupied by the business owner. But we are contemplating the market vacancy for the new constructions because we cannot calculate the chronic vacancy. That's why we are not giving chronic vacancy here.
Okay,
it's a lease up period.
Isn't every single retail unit, does not the tenant have to do their own build out? Are you not aware of this?
Oh, they do.
It doesn't matter. Like, the owner isn't going to do a build out until he knows he's got a lease signed, correct?
Yeah, that's correct.
Okay, so that's fine, and I don't want to argue. I just want to understand where you're coming from, and I think I sort of understand it. How long does it take for these buildings to absorb, in your opinion?
If I talk very particularly this building, within 2 years, as of now, it's all absorbed by the tenant.
Okay, so around 2 years. Thank you. Now, on the non-recoverables expenses, and I note that the assessment department no longer applies the non-recoverable cost or has reduced it from a total of 7% to 2%. Did you look at the statements of this property as to what they might be?
No, for this one, because it's a post reference, and also it's a combined for 400 Northtown and 350 Northtown. I did not recalculate it, but we are giving 2% non-recoverable. We only remove the management cost.
Okay, and 400 Northtown, which is the same economic unit, was in full operation at this point in time, was it not? 400
we-
North Town?
We don't, it is not a one economic unit. That's how the management company use. But for us, it's a two roll numbers. It's a two different economic units.
But I guess the question is, you did have the statements from an operational 400 North Town to review to compare them to your 2%, did you not?
For the 400, it's
Yeah.
a combined. But if you do, we have to consider the combined mailer.
Did you at any point in time look at similar market examples of neighborhood shopping centers to determine what their typical non-recoverable costs were?
For this purpose, no, I did not.
And when the city looks at the non-recoverables, are they restricting for the purpose of establishing the rate they've applied this year? Do they limit themselves solely to the income and expense questionnaire information?
Can you ask the question again, please?
Yeah, okay. Sometimes the mouth goes faster than the brain. When the city, I noticed that you don't have that description in your report, but usually the assessors provide a page. It's called a new look, I think, on non-recoverable costs.
Mm-hmm.
And in it, I just wanted you to confirm this, that their investigation into non-recoverable costs is restricted to only the information provided in income and expense questionnaires.
Honestly, I can't answer that question because those are decisions mostly made by the other divisions. To myself, I do not, but the people who are analyze those ones, I'm pretty sure they will be, and they did.
Well, so you're saying you know that's what they do, or you don't know?
I assume they do.
You assume they do. Okay. Now, what about costs that property owners incur that don't get reported to the city? Are they just ignored?
You mean the people who did not send the income expenses mailer?
Well, that's one, but maybe it's a question you didn't ask. Is there a mechanism to make sure that all the information required to determine non-recoverables is looked at? You don't go any further, and I'll be a bit more specific. In this particular case, it's owned by Investors Group. If a person looked on their public filings, because they're publicly traded, they would note that there's an additional fee on expenses of 2.6% for asset management. Now, would the assessment department have gone as far as to investigate this as a cost a non-recoverable cost?
I don't know.
Those are my questions.
Thank you. Ms. Lisbeth, do you have any questions of the assessor?
Yeah, just a little bit. Can you just explain how you selected your cap rate, please?
This cap rate is model driven based on the new construction and a neighborhood shopping center and the age and the area and everything. Based on that one, this is a model driven cap rate of 7.15. It's fall into the chart of a neighborhood shopping center. You can see 7.15 is the 20th percentile of cap rate for April 1st, 2018.
Okay, I do have a question then.
Okay.
Your lowest cap rate in your table is 6.15. So if this is a newly constructed neighborhood shopping center, and you've given it a cap rate of 7.15, what would it take to get a 6.15?
I think it's many factors.
Okay,
It's a location, size, and the construction type, and the other things too.
and can you explain what those, you said location and size, but what about location and what about size?
The superior location gets a better, higher cap rates. And
So is not considered a superior location?
this
I'm
is
just asking, I'm just trying to understand.
okay. If I consider Sterling Line or the Keniston Boulevard, if we compare with the Keniston Boulevard to North Town Road, Keniston Boulevard is superior than the North Town, but that's how those determined. This is a really, really good location. I really don't know how it will fall into the category of the superior.
Okay.
Then
So
7.15 is the model driven cap rate.
Okay, thank you.
Mr. McIntyre.
I have no questions, thank you.
Okay. Just to add to what Ms. said, I'm just wondering too, but I don't know if the applicant's arguing about cap rate. And under the circumstances, it looks like they got a pretty good cap rate, so I have to accept that they are. Anyway, Mr. Neufeld, you go ahead.
Yeah, sorry, I raised my hand twice. I was going to bring that up, but I wanted to not continue to be rude and interrupt. But no, I think we're not going to really deal with rents and caps.
Okay.
Wise decision, I think, based on what occurred.
Oh, don't say anything nice.
You go ahead, Mr. Neufeld.
Okay, I'm sorry. Yes. So what we're looking at here, and it's not completely cap off the table, but I'll rather explain what our view on it is when I get to there. But there's really two issues we'd like the board to look at. On the income side, we're very close. On the cap side, we're fairly close. What we're looking at is the vacancy. Now we have 15.6%, and that was calculated by on page 4, which is the rent roll, and this is a post-reference rent roll. But this shows after construction and a few months of absorption, the vacancy was still 15.6%. And with what the assessor was saying about how long would it take to absorb, and she mentioned it could be 2 years. I appreciate all that. But the other factor in first year absorption is the expenses and the free rent. And we've given you the entire rent roll, and we're not relying on it for market information because we're not disputing the rent. We wanted to show you how the first year absorptions really go. And you'll note in there as you go through them that there are a number of people who get 6 months free rent or tenant improvement allowances. So the vacancy does not stabilize until after 2 to 3 years construction. So between 2017 and 2018 construction occurred, it will not be considered to be absorbed until about late 2021, which is where we're at today. And so you're moving from probably 40% at the outset to a market rate of 4%, which we don't dispute at the end. But the period of the assessment appeal, we will have vacancy, which we estimate somewhere in the middle at 15.6%. So our snapshot in time is post-reference, of course, but there's no market on this. This is a factor that's related to absorption, and very, very common. For example, when we're dealing in the apartments, the assessor generally does one of two things. Either they allow for a higher vacancy for the first few years, or they push back entry of the roll, which of course is a little bit fuzzy. But the concept of first year absorption is very, very common, and that's what's happening here. So if it was put for sale in 2021 and you were using 2018 market data, an investor would say, I've got a building which can achieve these rents, but I know when I buy it, I'm going to be looking for a higher vacancy for the first couple of years. I'm therefore going to discount my offering price. That's where we're coming from. It's what would that investor have in his mind in April 1st, 2018, and it's 2 years of absorption time. The 15.6% represents what actually happened, and we believe that should be applied. We have some minor differences on some of the other factors, and the reasoning for it is, I think when the city changed their model on the 5%, we felt that they'd lost their credibility, and the whole model was a problem. Now, we do use a different shortfall, and the city is at $8 a square foot. But when one looks at the rent roll, we're using $11.61 a square foot. Those are the costs that are being recovered, and if you don't have a tenant in there, those are the costs that the owner has to pay. So those are actuals, and they are post-referenced by a year. However, we did compare them against 350 Northtown, who were up and open, 400 Northtown, who were up and open and are the same entity, and determined that, and I have those here as well, that number is correct. Almost virtually identical. I'm looking at April 1st, 2018 for 400 Northtown, and I'm looking at a number between, some of these vary depending on what they rent, between $10 and $11. So I think that's a fair number. Lastly, we have allowed a non-recoverable expense of $23,000 a year, or 5% of the potential income. And you'll note that that we use that 5% based after vacancy rather than before vacancy, so it is lower. The city, of course, used to apply a 5% and chose not to. The city of Winnipeg is the only entity in my knowledge who manufactures such a valuation model. It is not market. Now, where this goes into, though, is the concept of cap rate. If you artificially produce a statement of income, and because you don't put in your 5% recoverables, well, then your cap rate is going to be 5% higher. We don't know if the city did that in their cap rate calculation because they don't provide them. You have to make your cap rate the same way you make your valuation on your property. So if you're going to raise the income, you got to raise the income on the cap, which then shows a higher cap. So you'll note that ours at 7.5 is exactly, well, not exactly, about 5% higher than what the assessors applied at 7.15. And that's where this comes in. Again, the concept of valuation is not simply to take the 5 or 6 parameters and pick one that you like. It has to work together. So you can't say low cap, high income, but by the way, I'm not going to tell you how I worked out my number. So and back in 2018, when these rates became available to the city, of course, they were using 5%. So we don't know if they're doing it in caps or not, because they haven't said so. They've been less than transparent. And what you're getting in front of you is, it does not satisfy the burden of proof, because they have not been transparent on their calculations. Every other jurisdiction in Canada that I work in are far more transparent than this. It's a mystery. So what we're asking for is, we're content with whatever net income that you choose to use. We're so close it doesn't matter. We're asking for a higher vacancy rate. We believe we know the shortfall is actually higher. And on the basis of the non-recoverables, is our opinion is that you either apply 5% and use the assessor's 7.15, or don't apply it and apply 7.5. we need equity and fairness. Thank you. That's my presentation.
Rena, if you have any questions of Mr. Newfield, you can ask them now.
Yes, Mr. Chair, thank you. Mr. Newfield, I'm asking question regards to income expenses mailer. You can focus either my income expenses mailer or your income expenses mailer. Attach with your brief. I mean the I submit. Sorry, my. So the same thing. Do you see the management expenses, which is we believe to be 5%? It's recovered fully from the tenants. Did you see that?
Yeah, but that's a different factor altogether. There are asset managements which are not fully recovered, are not recovered at all, and the concept of the 5% that the city called management, and I know this is before your time, in testimony at municipal board, they were quite clear that they weren't for property management. They were for all the other non-recoverables associated with running a property. For ease of labeling, they always called it management. And I'm jumping your question to the next one. I apologize.
Okay. My next question, the same thing, that they recovered all the expenses. They recovered the common area and taxes and management and everything.
Well, no, they didn't, because on page 7, you'll note that there's about $63,000 in non-recoverables.
Do you believe those are for the already vacant, already not occupied units?
Well,
at that time,
no, because what's gonna happen is that after you absorb, then you're gonna have turnover, and then these expenses keep recurring, and rather than and this again went back to a very misunderstood hearing where I believe someone argued that you should be able to write off your TIs and your commissions on both the rent and 5%. The board said, no, you can't take them off the rent because we already allow 5% for that. So every year you do a turnover, you're going to have more commissions, more TIs, more non-recoverables. The way to look at this is forget about how this is structured, but look at the bottom line, and you're an investor in this property, and someone says you're going to get a return. By the way, we're going to ignore the non-recoverable, and the guy who owns a piece of it says, well, but I'm not getting that money, am I? No. So that's where you have to be looking at it. Look at the end person, the investor. How much money is he putting in his pocket? And there's been too much blurring of the argument by honestly people who really don't practice professional real estate. I talk to investors every day. They don't care about this nonsense of where it's categorized. All they're looking at is when my check comes in, what percentage is it going to be? And that's why we're quite adamant that you have to allow for it in some way or another. If you want to take it away, all your caps have to be higher. Thank you. Sorry, that was my answer.
Okay. One more question, Mr. Newfield. Sorry, asking questions. Your structural reserve of 25 cents per square feet and shortfall of $11.61 per square feet was calculated based on the post reference. Is that true?
Yes, I went through the shortfall before, and the issue of the structural reserve is in past years, the 5% was for non-recoverables. The 2% was deemed to be something equivalent to structural reserves. And when we look at that, what your calculation was at 27,000, ours compares at only 12,900. And it's an actual lower amount because the structural reserve is generally for roof replacement, which is never part of a lease. And so we've calculated out 20 years of roof replacement. How much money do you need every year? and as a property management company, there's always a structural reserve.
Okay. Actually, that definition make me to ask another question, because our other expenses, we have different labels. I know the way we understood, we use a different label, you use a different label. We call expenses that include the other and the structural reserve. We use 27,368. If you calculate your structural reserve and unrecoverable, it's going to be higher than ours. It's
Yes.
23,000 and 12,000.
It's the
It's
total.
a little bit higher, but it's very close.
The total of ours is 36,000, and yours is
It's
27,000.
27,000. It's close and high.
I think that you're right, and the major difference is the vacancy and then the associated shortfall.
Thank you, Mr. Chair. That's all my question.
Thank you. Has Lisbeth any questions?
No questions.
Ms. McIntyre?
I have no questions, thank you.
And I don't either. Thank you. We will now go to item number 1 on the agenda. Which is 939 Notre Dame Avenue, file number 1. And Mrs. Session, you can go ahead when you're ready.
Thank you, Mr. Chair. Property file number 21208. Property roll number 1306029300. Property address 939 Notre Dame Avenue. Property owner Computers Plus Limited. Property was assessed for 376,000 for reference roll year of 2022. If I talk a little bit more about this property, the property was 2020 valuation was lower than 2022 valuation. The reason for that, from the year 2020, we used the smaller square footage, which is before the supplemental we send in 2021, because this is not the supplemental assessment, but this is the owner appeal for 2022, but we have different valuation in year 2020 and year 2021 and 2022. This owner bought this property in 2017, December, and they did the addition and the renovation within that period. Then we issued the supplemental assessment on effective January 1st, 2021. That's why the value increased from 2020 to 2022. The current value is 376,000 as of the condition to the property in January 1st, 2021. Physical condition. You can see the pictures for this property in page number 11. 2016, property owner owned by different person is a different look in the property. 2018, it's under construction. 2019, it was constructed by own operate new business start operating out of there. So that's the main reason for this valuation is higher than the previous years. The property owner bought the property in 2017 December for 230,000, and he did entire addition and the exterior interior renovation. And I have my comparables here in page 13. Comparables with the close proximity. It's all range. It's a rent range showing $12.48 to $15.16. We use $13.93 overall rent to calculate the property assessment. We use the model-driven parameters, 6% vacancy, 2% expenses, and $6.50 shortfall, and capitalization rate of 8.5. Then finance value will be 376,000. We have sales mailer attached here in page 8 and 9. And also I have attached the just the blank mailer they sent it to us before the possession. I'm not, and based on the current condition of this property and reference period, I'm asking to confirm the value as it is. Thank you, Mr. Chair.
Thank you. Mr. Newfield, any questions?
Yes, you said there was an addition on it?
Yeah.
Well, where was the addition?
You can see the picture plans on page 13. That 49 feet by 15 feet area was added after they purchased the building.
Sorry, I'm looking at that, and I'm also looking at overhead. Where is this addition?
You can see that building picture in page number 13 bottom.
Okay.
Can you? Yeah.
Yes.
Okay. You can see that's 49 feet by 49 feet and 6 inches time 15 feet by 4 inches space.
Right.
It was added to the building after they moved in.
And when was that done?
It's a period of 2017 to 2018. I did not put the cost or permit things here because it's a post reference.
Okay. So the you're saying that the portion that was added was on the lower part of the building. It was long and narrow, and an addition where I guess where it says coffee bar. You're saying that was added?
Yeah, it was. Yeah, it's
okay.
Coffee bar was added because 2020 valuation we have the smaller area. We have only the main building only. 2022. Then actually effective date for this addition January 1st, 2021. Then,
so that's what confused me here, because these these drawings date from 2018.
Yeah, that's true.
Okay.
Because the owner purchased in 2017, he submitted all the permits in 2018. He did all the renovation and he did all the addition.
Okay. On page 13, it says the square footage is 2,514. You're using 2,570. Why is that?
2,514.
Okay, you see that on page 13, bottom right corner?
Yeah, I think this is without the exterior wall measurements, because sometimes when they send those ones, they only send the interior measurements, because this is a single occupant building.
So you think, you don't know this? I mean,
I did not calculate this one.
You're asking about.
Yeah, I did not. Before that, I did not calculate because I did not notice that 2,514 on the bottom. If I saw, I would calculate.
Yeah. Okay, and the original building was, how big did you say?
Original building 1,758.
Okay. I'm just quickly adding up the measurements that looking here, and I'm seeing that, and I could have double checked my numbers here, but did you look at these measurements? I'm talking about the ones on the side. It's 58 feet 7 inches, 24 feet plus by 19.3, that's somewhere around 1,590 square feet. And then below 49'6" by 15'4" is about 757 square feet.
Yeah.
So I got a totally different number. I get 2347. Okay, well, there's a slightly different number up top, 85 by 20.6.
Yeah, you can see that discrepancy in here because it's sometimes measured drawings come with a little discrepancy. Even it's showing here.
No, I exactly. I'm not doubting any of this here. I just want to make sure. See, when I'm looking at the top drawing, which is a little bit better, easier to read.
Yeah.
It's external measurements is somewhere closer to your number, but we have a contractor who says 2514.
Yeah, I know about the situation. We are going to get this kind of thing very commonly because they submit from the drawings beginning, it's inches, 2 inches here and there change. It's happened most of the time, but we don't hang up on those kind of small differences sometimes. You can see the bottom and the top is different already.
Okay, and your rent comparables, they're generally from McPhillips area?
Yeah, that's McPhillips and Isabel and Main Street.
And Main Street, and then one on Isabel. And do you have anything like a little closer to this market?
No.
Right. Sorry, I have one last question, and let me just get to it. So did you happen to determine what the current rental rate is, or is that all post-reference?
I think they did not report the rental rates. And also, if it's reported, it's a post-reference.
Right. That's all I was wondering is what if there was a report on there. Okay, thank you. Those are my questions.
Thank you. Any questions, Ms. Lisbeth?
No questions, thank you.
Senator McIntyre?
I have no questions, thank you.
And I have no questions, thank you. Mr. Neufeld, you can proceed with your evidence.
Yes. We had a slightly different square footage, and I know we're not that far apart. We had come up with 2550, and that was provided by the owner. And I take it he just looked at the measurements that were on the contractor's drawing and provided them to us. And for our rents, we were looking at a number of properties on page 3. And these are fairly diverse, going across downtown West End and even out a little bit further. But about the middle of the page, we have a number from the general West End area. And they do vary from lows of 655 to highs of 1223 for the area. And that's what you'd be expecting to see. Not a great deal of rental properties in the specific area. We applied a rate of $9 a square foot, and the other differences are our vacancy rate was the same because it does coincide with general market reports, rather than do the way the assessor did in terms of non-recoverables. We chose 5% of income and then again a structural reserve. again, we do not have confidence in their new model. Shortfall, we have done our own estimate. We're very close, so it's not a major issue. In terms of capitalization rate, this is not a good investment property. People aren't going to beat the doors down for it. I know that the assessor seems to be fairly close to ours at 8.5 and 9.25. I think we're in the same neighborhood. We're close to each other, and you know, I think on something like this, we think that likely both of our opinions bear some weight, and we would consider a slightly lower cap. We don't think it's as low as 8.5. As far as some evidence, we don't have a lot of investment properties cap rates recorded because, again, these properties rarely trade on their income. Generally, they're owner occupied, and there's an element of that in it. There was a couple I was looking at in our report on the retail side. On conversions, and on page 38 there's a few, and the ones to consider are one was 848 Jubilee, which was a conversion, and that supports the assessor. But then if you look at 819 Sargent, which is a retail strip, similar locational disadvantages, 10.8%, although it's a bit dated. Lilac on page 39 was a conversion at 9.47. I can't say that there's any smoking gun here for cap rates, because generally these types of properties in the real world would get valued on a per square foot basis. And when I saw the sale at $230,000, which would work out to $100 a foot, that's pretty close to what you're going to see in the neighborhood, in and around $100 a square foot. I did not prepare this document, but and I can't, opinion of value on this at $100 a square foot, although it would show slightly higher than we have in here. I think that that's where this market sits. I did not give you any evidence. My function, just so you know, here is I'm an appraiser, so I didn't do this workup. I can only comment on it as a consultant who's being brought in to present it. And I think that my experience would show that likely $100 a square foot would be where it would go. We didn't give you those numbers, but the rents are supportive. The ones we brought forward are supportive of this, and I think we have room to maneuver in the capitalization rate. That's my presentation.
Thank you. Mr. McIntyre, I'm sorry, Assessor, you have any questions?
Yes, Mr. Chairman. Thank you so much. One question. This property bought in 2017, December 20th. Owner paid $230,000. You and me both believe the property size would be 1,500 approximately at that time, based on the plans. We don't have much information to rely on right in front of us. But 230,000 divided by 1,500 square feet, I get the 153 assessment square feet, 153 for the per square feet. If I divided 376,000 divided by 2,500, which is current size, I will get the $150 per square feet, which is very close. Do you believe $150 per square foot would be the better rate for this location and this property?
I understand.
Based on the sale.
I know, and I understand what you're saying, and that's really not the way you value things. It's speculation.
But you brought up this theory.
It's really a back of the envelope style of thinking, and here's what you fail on that calculation. when it was smaller, it had more parking. Now that you've taken and developed more, you have less parking. So you're going to get lower rent because you have less parking. So there's another factor that goes into it. And if you change the use, do you get a better use in this? One of the problems with focusing on the sale, and that's the other thing, is this particular property owner owns the space next door at 943 Notre Dame. That's immediately west.
I know.
And so this fits in with him, with his operation there and on that particular site. And I don't know if we put this in as the rent, because his rent there was $7. And I just want to see if I put that in the table here at all. No, but I just slipped that in. It is part of a larger economic development. I did not prepare this myself, and I think the people who prepared it were not quite aware of all of these factors. So it's verbal, and take it for what it's worth. But but we know that he owns next door, so that's why I couldn't use your method. He's also in the middle now of putting a new lease on the property next door. So there's some issues with having it fit in with this one. So there's some, what do they call them, synergies involved that aren't necessarily fee simple.
That's all my question, Mr. Chair. Thank you.
Thank you. Mr. McIntyre, any questions?
I have no questions, thank you.
Mrs. do you have any questions?
No questions.
And I don't either, thank you. Okay, so we'll now go on to file number 2 today. Second matter on the agenda, 428 Academy Road. And when you're ready.
Okay, thank you, Mr. Chair. File number 21221, roll number 120526262000, property address 428 Academy Road, owned by
Mr. Chairman, the assessor sent me something. I only got it this morning, and it was a recommendation.
Yes,
and,
I did send the recommendation.
And I think we're close, and I haven't been able to track down the owner just to pass this by him. We were content to go with the assessor's recommendation on the basis that, if the owner has an issue with it, we would appeal it further rather than spend any more time on it today, if that's okay.
Okay, so do you want to put forward the recommendation that you recommended, please?
Yeah, my recommendation based on the, give me 1 second. Thank you. My recommendation to reduce the value 411,000 for the property based on the blended market rents.
Okay, so, Mr. Nichols, you indicated that that's acceptable, at least for the time being, as far as you're concerned. And
Exactly. I think it should be okay, but I have to get the owner's approval, so I don't want to promise anything I can't deliver yet. But I think it's the end of it.
Okay, well, it will be as far as our board is concerned.
Right.
Okay. Thank you. Any questions, board members?
No questions.
No
I
questions.
don't have either. Thank you very much.
Thank you.
Thank you. You'll hear from us.
Right.
Thank you. Have a nice day to everyone.
Is our meeting now adjourned?
Our meeting is adjourned.